the topic that John McDonald and I chose has turned out to produce a wealth of information and problems. And so I think we're just going to scrape the surface, but I hope you'll find it an interesting exercise. I'm going to kick off with avenues of recovery for motor insurers. I think when I came to the bar, motor insurers were rather reluctant to sue each other for recovery, where both insurers were interested in the same claim, certainly if it was in relation to the same person insured under different policies. But nowadays, with the vast claims that are coming out of the personal injury industry, insurers seem to be more interested in getting some recovery from other parties, including co-insurers. I'm going to start by just identifying the three sort of areas of liability that a motor insurer can incur. Firstly, of course, the contractual liability, where the insurer is liable to the driver or user who's entitled to indemnity under the terms of the contract of insurance, including, I will bring in here, certain impermissible exclusions which are to be ignored under section 148 and 1513 of the Road Traffic Act. Clearly, however, there are exclusions which are permitted by the Road Traffic Act, and we know there are cases where that is relied upon. Then the second form of liability is Road Traffic Act liability, where the insurer is bound under section 151 to satisfy the judgment obtained against the defendant driver for his negligence. And thirdly, there's what's called Article 75 liability, where the insurer is not liable under section 151, but is liable to indemnify the MIB in its dealing with the claim under the Uninsured Drivers Agreement of 2015. So let us take an example, if we may, in fact, against where there is a non-driving tortfeasor, just to explain how judgments, as it were, work. So my example is one of a landowner or highway authority who has negligently allowed a tree or a branch to fall into or obstruct the highway so as to cause a collision between the tree and the motorist, and thus injury to a passenger. And I take an example in which the driver is only 20% to blame because the tree was so difficult to see, and the tree owner is 80% to blame for the accident. The passenger establishes liability against both. Now, the important point is point 3 on this slide, which is that the passenger is entitled to recover 100% against each defendant. When the judge at the end of the case apportions liability between defendants, 80% and 20%, he's not pronouncing that one is 80% liable to the claimant and the other 20% liable. The claimant is entitled to judgment in the full sum against each defendant. He obviously can't enforce beyond 100%, but he can enforce against each defendant to the proportion that he wishes until his judgment is satisfied. So going on, let us see what happens when the insurer is contractually obliged to indemnify his insured. If the claimant enforces 100% of the judgment against the motorist, the insurers must indemnify in respect of that 100%. He's then subrogated to the judgment that has been made in favour of the motorist to recover 80% contribution from the tree owner under the 1978 Civil Liability Contribution Act. So the insurer ends up paying a net loss of 20% of the claim. Conversely, if the claimant enforces the whole 100% against the tree owner, the insurer is obliged contractually to indemnify the motorist in respect of the tree owner's judgment for 20% contribution. So again, the insurer ends up paying 20% of the claim, and that's all simple, as they say, fine and dandy. Now let us look at the RTA insurer who has to pay a judgment against a driver who was not, say, permitted to drive under the policy. So there is a section 1512B liability, which is converted into an obligation to pay the judgment. Again, if the claimant enforces 100% against the motorist, the RTA insurer must satisfy that judgment pursuant to section 1515. And so he's paid 100% of the judgment. The insurer doesn't have a direct claim in contribution against the tree owner under the 1978 Act, because they're not liable in respect of the same damage. See, Jubilee Policies and Volvo, a rather badly reported and ill-argued case, but I think it's authority for that proposition. The right to 80% contribution is in favour of the uninsured motorist. But in my view, the insurer, by having paid under section 1515, is subrogated to the uninsured motorist's claim against the tree owner and can claim by that route the 80% contribution due from that source. Alternatively, if you have to go the heavy route, as it were, you're entitled under section 1518 to sue the uninsured motorist for the judgment that you've had to pay. And although the uninsured motorist has no cash in hand, he does have the right to reclaim anything that you recover against him to the extent of 80% from the tree owner, so that ultimately, by one route or another, the insurer can get his 80% contribution back from the tree owner. Incidentally, in the Volvo Trucks case, the insurer failed by this route, but that's because he didn't get his ducks in a row, and he was trying to bring a subrogated claim in his own name and not in the name of the uninsured motorist. One needs to do both, in my opinion. But going on, let's look at what happens if the claimant enforces the whole of his judgment against the tree owner. Now, in this case, the tree owner's judgment for 20% contribution against the motorist cannot be enforced against the insurer. And that is Court of Appeal authority in the case of Breton and Hancock. So this means that if the road traffic insurer can persuade the claimant to enforce the whole of the judgment against the tree owner, the road traffic insurer will avoid having to pay the 20% contribution which his uninsured motorist has to pay. So there's a rather strange asymmetrical outcome, which is entirely dependent on whether the claimant enforces the whole of the judgment against one tortfeasor or the tortfeasor, or under section 151 against the insurer. And one doesn't like, first of all, asymmetrical results, and one doesn't like results which depend perhaps on the whim of a claimant as to who he or she is going to enforce the judgment against. But the question is whether we've gone far enough. And this is the question, and I don't know what the answer is, but I put it in the language of unjust enrichment and restitution, and put the proposition as follows. Where a tortfeasor, the tree owner, has committed a wrong jointly with another tortfeasor, the motorist, but a party, the insurer, without being a wrongdoer at all, is subject to a liability imposed by statute to satisfy the joint and several judgment obtained against the motorist, should the tree owner be considered to have been unjustly enriched to the extent that he benefits to any extent from the obligation of the insurer so imposed by statute. To put it again in more legal language, should the obligation involuntarily imposed on the insurer be treated as secondary to the tortious obligation undertaken by the tree owner, so that the latter can be forced in all circumstances to repay to the insurer 100% of all sums which the insurer has been forced to pay? Personally, I don't think so, because a road traffic insurer has taken premium, knowing that that premium puts him into the Section 151 frame in certain circumstances. And I think that will be held against him. But on the other hand, it can properly be said that you have a tortfeasor on the one hand and a faultless party on the other who are sharing a judgment. And so there is some merit in the argument. The merit in the argument is perhaps corroborated by the position when you look at the case against the MIB. Suppose that the article, your insurer, you, have managed to get rid of Road Traffic Act liability for some reason or another. But you remain the Article 75 insurer. In other words, the MIB still has to pay this claim under the domestic agreement, and you have to discharge the MIB's liability. Now, the MIB is treated as an insurer of last resort, and its agreement with the Secretary of State, the domestic agreement 2015, does give the MIB, the Article 75 insurer, the rights, first of all, to force the claimant to sue the tree owner at, of course, the MIB's cost and risk of cost, and to force the claimant to enforce 100% against the tree owner. Or to put it another way, it has the express right to take an assignment from the claimant or of the claimant's joint and several judgment and to enforce it against whomsoever, which will obviously be the tree owner and not the motorist. Sorry, not the Article 75 insurer. It has the right, therefore, to refuse to pay any contribution to the tree owner, and Breton and Hancock would equally apply to the MIB agreement. So one sees at the end of the day that where there is a second tortfeasor, the MIB stroke Article 75 is entitled to get out of paying anything, provided that there is a second tortfeasor who's liable to any meaningful degree. I've then gone on from the tree owner to a second insured motorist, but really there is no particular difference between those two scenarios, except in the case of paragraph 3 on this slide, because where there are two separate motorists being pursued and there is a dispute as to whether one of the motorists is really to blame at all, there is a procedure for establishing a meaningful degree of negligence on the part of a motorist who has an insurer behind it in one form or another, usually another Article 75 insurer. And the internal procedure arises under Article 75, and it can be summarily determined by the technical committee or under the fairly swift arbitral procedure laid down by the MIB articles as to whether there are liabilities on the part of two separate motorists. But otherwise, we can really treat the second insured, the other tortfeasor being a second insured motorist in the same breath as looking at the case of a separate tortfeasor who's not a motorist. So let's go on to a single negligent motorist who can look to insurance companies. The most common example is where one insurer insures the vehicle and permits under the policy any driver to drive that vehicle. And the other policy is one that insures a driver to drive his vehicle, but also under DOC cover insures the policyholder to drive any vehicle. So you have two separate policies issued by two separate insurers, but they both cover the negligent driving of the vehicle by this particular driver. Now, there used to be a non-binding agreement in the motor insurance market by which it was agreed that in such circumstances it was always the vehicle insurer who indemnified and would pay the whole claim. But that was never actually legally binding. I think it was probably recognised in the market. It now seems to have gone without trace. No one quite knows where it went, but it certainly doesn't seem to play any part at all in negotiations and discussions between insurers. So when you have two insurers like this, there is a basic rule of contribution in equity that each insurer pays 50% of the loss. The insured has the right to choose which insurer to pursue, and that insurer has to pay 100%, and then he has his right in contribution in equity against the co-insurer for 50% of the loss. But of course, that all depends on the terms of the policy. And in the bankers' trust case, the bankers' and traders case, which I refer to here, the vehicle insurer insured any driver, and the driver also had his driving other cars covered. And rather strangely, in that case, which came from a Commonwealth jurisdiction, the vehicle insurance policy had a term, had an exclusion clause that excluded cover to any driver in circumstances where that driver was entitled to indemnity under any other insurance. And so in that case, there was not co-insurance because the escape clause in the vehicle insurer's policy was effective, and the sole claim that could be made against insurers was against the driving other cars cover. In the UK, I think from the early 30s, insurers were wise to this one, so they always put in a term saying if you've got cover under another policy, we won't cover you. And they went rather optimistically to the court in the case of Weddell and Road Transport and said that neither of us had to cover this poor benighted motorist, because although he's taken out two policies, in each case we can say you can't be covered by us because you're covered by the other. And it goes round and round in circles till you go down the plug hole, but the answer is we don't have to pay. Well, that didn't cut much ice with Mr. Justice Rowlett, I think it was, and he said that they just cancel each other out. And I think in the modern era, everyone agrees that. So if you have two of these exclusions, they cancel each other out and you're back to square one. In a case that I was involved with called AXA and EUI, the driving other cars cover was limited to driving privately owned motor vehicles. And the driving other cars insurer said, well, that doesn't cover you when you're driving a car which has been lent to you under a commercial deal with a garage under which they give you a free loan of the car whilst your car is being serviced by them at enormous expense. And that succeeded, and the result was that the only insurer that had to pay there was the vehicle insurer. There are other problems that arise, and there is a famous conundrum which arises from two cases, Legal and General and Drake and Eagle Star and Provincial, and forgive me if I get them mixed up. But the Court of Appeal decision looked at a case where one policy had an exclusion which had bitten, as it were, by the time of the accident. The other policy had an exclusion which didn't arise until after the accident, i.e. an exclusion of liability if you fail to notify us within X weeks. And so the latter insurer said, well, we're not liable. And so we don't have to pay at all. The Court of Appeal said, no, you must look at the situation that arises at the moment of the accident. And so you ignore any breaches of condition which post-date the accident. The right to contribution between insurers depends entirely on the situation in equity at the moment of loss. Then came along the Privy Council in Eagle Star and Provincial 2 years later, which said exactly the opposite and said that you look at the contract, you look at the contractual obligations of both insurers at the date when the claim for contribution arises, i.e. when one insurer pays the claim. So that is an unresolved situation which will no doubt continue to concern the courts to some extent. The other thing that arose in one of those two cases, and I can't quite remember which, is the danger that is created by rateable proportion clauses. Most policies now seek to anticipate the question of contribution between insurers by saying in the policy, if this policy responds in conjunction with another policy, then we will own, or other policies, there could be three, then our payment under this policy will be limited to the rateable proportion of our contractual obligation. So in other words, if there are two insurers, we will only pay 50% under this policy, and you must get the other 50% from your other insurer. And those, although very unpopular in the eyes of the court, are clauses which bite. And they had a disastrous effect in the Legal and General and Drake case, because in that case, Drake had paid out 100% of the claim to the victim because it had to under the Road Traffic Act. And when it came to seek its contribution from Legal and General at the last minute said, well, wait a minute, you didn't have to pay 100% of the claim, you only had to pay 50%. So you don't have a claim against us for contribution. You paid the second 50% as a volunteer. And as a volunteer in equity, if you make a payment, you don't have a right to recoup it. And the Court of Appeal found against Drake on that one as well. Drake then tried to turn the tables in 2004 in a case called Drake and Provident, where exactly the same thing had happened. And they said, oh, well, Provident paid 100% here under Section 151. And so we don't have to make any contribution because Provident paid the second 50% as a volunteer. And the Court of Appeal again, this time against Drake, they decided that if Provident pays the 100% under statutory obligation and under protest to the other insurer that the other insurer is in truth liable for the share, then it is not treated as paying as a volunteer. So there are quite a number of complications that arise in the case of two insurers. And particularly when one gets the interplay between RTA liability and contractual liability. One question is a driving other cars insurer liable under the Road Traffic Act 1988? Question one is that insurer subject to Section 148 of the Act, which restricts the number of and type of exclusions that you can put into a policy of insurance. And in Advantage and Stoodley, Master Davison decided, and I think quite logically, that yes, this is an insurance policy which is required. The DOC cover is required by the driver to make sure that when he does drive other cars, he won't be in breach of the law. And so, as it is that sort of insurance and is provided for that purpose, Section 148 must apply, and you discount any exclusions which contravene Section 148. But does that go as far as Section 151? Does the DOC insurer have to satisfy a judgment under Section 151? Now, in Bankers and Traders, the DOC insurer did have to satisfy a judgment under what was the equivalent of the pre-1988 Section 151. But there, the liability in there was a liability in contract and a liability under Section 151, and the Section 151 permission to enforce was really just a convenience. The problem with saying that Section 151 does apply is when you look at Section 151 2B, you see that if there is a liability which would be covered by the policy, that's the DOC policy, if the policy covered all persons. Now, that can't apply to a DOC cover, because if you give someone a cover to drive any vehicle in the world, and that is then fed into Section 151 2B, you have a liability which would be, and if the policy was then, under this hypothesis, granted in such a way that it insured everybody in the world to drive every vehicle in the world, you've got a complete nonsense, because that means that the DOC cover of every insurer in the world covers every accident that's ever happened in the world, and that is an obvious nonsense. So in relation to Section 151 2B, when it says a liability which would be covered if the policy insured all persons, that must mean if the vehicle policy insured all persons. And so it can only apply to a judgment which is related to a particular vehicle, and the insurer of the vehicle has to pay. And so the DOC insurer won't have to pay. But it does mean that the word policy in Section 151 2A and the word policy in Section 151 2B mean different things. So it's another conundrum. In the case of a DOC insurer and a vehicle insurer who's only an RTA insurer, the victim can choose to enforce his judgment against the RTA insurer or against the DOC insurer under one of those two sections, or through the contractual insurance chain. Now, it seems to me that the RTA insurer can seek equitable contribution to the extent of 100% of his outlay. That seems to be implicit in both the Legal and General and Drake case and the Eagle Star case, where it was assumed that a contractual insurer has to pay to the exclusion of one whose liability is imposed purely by the statute. And that is justified by the fact that if the RTA insurer were to have to make contribution, he could pursue his rights under Section 1518 to reclaim the sums from the driver who held the DOC cover. And the driver who held the DOC cover could then pursue his insurers for an indemnity which arose out of his driving the other car. So I think it's right to say that if there's a contractual DOC insurer and an RTA vehicle insurer, the DOC insurer has to pay the whole shooting match. You then have a more complicated or more difficult situation where you have a DOC insurer and Article 75. Now, a DOC insurer can never be an Article 75 insurer because Article 75 says that an Article 75 insurer should mean the member who, for the time of the event which gave rise to the Road Traffic Act liability, was providing any insurance other than by reason only of a driving other vehicle clause in respect of the vehicle from the use of which the liability of the judgment debtor arose. So a DOC insurer will never be an Article 75 insurer. Obviously, if there is an Article 75 insurer and a contractual DOC insurer, again, the DOC insurer will have to pay the entirety of the claim. John, I apologise for going over my time limit, but we've got through quite a lot of material, and clear your brains for some more conundra relating to use of a vehicle and liabilities arising out of that use.
Thank you, Howard. What I'm going to talk about is perhaps something that's a bit more colourful, although narrower in scope than Howard's wide-ranging talk about recovery. Do motor insurers have to meet road rage claims? And what about claims by passengers leaving or returning to a motor vehicle, or claims against passengers in vehicles? And what about claims in respect of incidents that occur before or after a journey has taken place? Can it be said that they arise out of the use of the vehicle, or that its use is merely incidental to the injury, loss and damage? You can see on the slide that the relevant provisions of the Road Traffic Act are short and sweet. Section 143 is, strictly speaking, a section that provides for criminal sanction in respect of not having motor insurance. Section 143 insurance must consist of, it must cover liability in respect of death, injury or damage to property caused by or arising out of the use of the vehicle on a road or other public place. It's important to the statutory duty is on the user, usually the driver, and not the insurer. And as Howard's case of Bristol Alliance and Williams established, you don't have to and so, for example, if a policy excludes or deliberate damage or racing, there's no contractual obligation on the insurer to provide cover. The obligation is just to have on the user to have such insurance. But under the MIB agreement, MIB has to meet unsatisfied judgment in respect of everything where the liability falls within Section 145. And by the MIB's Article of Association, the insurer, if an insurer is providing any insurance, even if it excluded such claims, then they must meet the claim, or they usually have to meet the claim as Article 75 insurer. You also have to bear in mind there's a lot of PL and EL policies define the limits of their cover by reference to what is compulsorily insurable under the RTA. And so you need to look at Section 145 for that purpose as well. What then is the scope of the RTA requirement? Caused by is relatively straightforward. Arising out of and use give rise to much more difficult concepts. The leading case in England, and indeed the only case in the Court of Appeal directly on this point, is Dunthorne and Bentley, and it nicely demonstrates how the courts will give it a pretty wide meaning. In that case, the defendant was driving her car when it ran out of petrol. She parked by the side of the road, and when by chance a colleague stopped on the other side of the road, she ran across towards her. She was struck and fatally injured by a car driven by the defendant, who brought a claim for his own injuries. And it was held by the Court of Appeal that while the case was close to the line, the claimant's injuries arose out of the use of the defendant's car, and so her insurers had to meet the claim. The claim came into a certain amount of criticism But recently, in the Supreme Court case of Pilling, it was held expressly by Lord Hodge that Dunthorne was indeed correctly decided. So we need to look quite carefully at the concepts of use and arising out of to see where we go in respect of these contentious cases that I'd like to consider. First of all, use. In Pilling itself, Lord Hodge said the English case law, in English case law, use has been interpreted to extend beyond driving a vehicle, so that an owner had to have third-party insurance if he had used the vehicle on a road. Thus, for example, a person who left his broken down vehicle on a public road without a battery and without any petrol in its tank was convicted of unlawfully using the vehicle without there being third-party insurance in force. That was Elliott and Gray. He gave another example of a car where it had been parked on a public road for over 7 months, during which time the rear brakes seized, the tyres deflated, and the gearbox ceased to contain any oil. And the user was still there, the owner was still then convicted of using the vehicle without motor insurance. The statutory concept of use in this context, said Lord Hodge, is that the owner has an element of control, management, or operation of the vehicle while on the road. But uncertainties remain, and I highlight 4. Just how wide is this concept of use? Second, at what time should the use be considered? Third, at what locations does the use of the vehicle have to be covered by insurance? And fourth, who is to be regarded as the user? So far as the nature of the use is concerned, in Pilling itself, the Supreme Court reiterated the need to construe Section 145 in the light of EU law. And even though we've now got Brexit, the EU Withdrawal Act 2018 has in general preserved such obligations even after Brexit. You're mostly, I'm sure, familiar with the case of Vanook, which was a man knocked off a ladder by a trailer on private land. And it was held by the European Court that use of vehicles covers, quotes, any use of a vehicle that is consistent with the normal function of that vehicle. And even though the court has tried to row back a bit on that in subsequent cases, such as Andrade, it still meant that the use of vehicles on private land and the use of vehicles other than for their primary purpose for use on roads required to be covered by insurance. What has now come into law, without in fact all that much fanfare, is the Motor Vehicles Compulsory Insurance Act 2022. And for accidents occurring on or after the 28th of June this year, a new section 156A has been inserted in the RTA, which provides that liability in respect of use of vehicles other than motor vehicles, and I choose those words carefully because those are exactly what the statute says, other than motor vehicles, does not need to be covered by insurance. It's an interestingly ambiguous provision because the explanatory notes in the bill state that it's intended to both reverse Vanook and to make it clear that the insurance required for vehicles is not required for vehicles not constructed for road use. I'm not sure how successful the provision will be achieving at least a second of those objectives, but perhaps beyond the scope of this talk. What about time of use? In Apson and Warboys, and I'll come to the facts of the case in a minute, the judge concluded as follows. The relationship to which the words arising out of must be applied is between the injuries suffered, not the negligent and wrongful acts, and the use of the vehicle, not at the start of the journey, but at the time when the injuries were suffered, as was shown by the approach in the case of Dunthorne and Bentley. In Carroll and Taylor, which is the most recent High Court case on the subject, the judge there agreed with the approach. But while the approach may be valid in the majority of cases, it may not apply, for example, in road rage cases. You take the following example. A motorist is irritated by the conduct of another road user. He parks, switches his engine off and gets out of his car and walks over and assaults the other road user. It may be argued that the assault arose out of the motorist's use of his car, but at the time of the assault itself, either it could be said he was not using the vehicle at all in any meaningful sense, or the assault did not arise out of its use, at least at that time. Location abuse I'll deal with briefly. Once again, the Motor Vehicles Compulsory Insurance Act has got something to say about that, and section 156A(1)(b) of the RTA as inserted by that act now reverses the effect of Lewis and Tyndale. So it means that there is no requirement on anyone, MIB or otherwise, to meet claims on private land. Who is a user? Slater and Buckinghamshire was a case where it was noted by the judge in first instance that a number of authorities have decided that the user of a vehicle is a limited class of person. He gave the examples of the driver, his employer, or his principal and the owner of the vehicle. But thus in that case, it's held that the user did not include passengers, including fellow employees of the driver, who may have duties to perform in the vehicle in relation to passengers. Contrast that with a recent case in the European Court, BTA and Baltic. In that case, and it shows what important matters the European Court was concerned with, the passenger in a vehicle parked in a car park opened the door of that vehicle so as to scrape the vehicle parked next to it. And it was held that that was something that was compulsorily insurable. How that inconsistency between English and EU law can be reconciled remains to be decided. Dunthorne and Bentley. As I've mentioned already, it's pretty obvious that arising out of is wider than caused by. And in Dunthorne and Bentley, Lord Justice Pill referred to the Australian case of Green and Lloyd, in which it was said, arising out of extends to this result that is less immediate, but it still carries a sense of consequence. It excludes cases of bodily injury in which the use of the vehicle is a mere causal concomitant to be considered to be, in a relevant casual way, a contributory factor. So as regards the circumstances of Dunthorne, the reason why pedestrian was in the road is one of the factors that has to be taken into account in deciding whether or not the accident was caused by or arose out of the use of the vehicle. And it might, for example, have been held that if for example, the motorist had parked the car, turned the engine off, turned the key in the lock and simply walked across the road, that it would have been held not to have arisen out of it. The clincher in that case seems to have been that it was in order to get petrol, in order to continue her journey, that made the Court of Appeal consider that it arose out of the use of the vehicle. Look at some of the other English cases. Slater and Buckinghamshire, as I said, was a case involving a boy suffering from Down syndrome who was run over as he crossed in order to reach a minibus on the far side of the road, encouraged by the helper on the bus. And he was held by the judge that to interpret arising out of the use of the minibus to include circumstances giving rise to his accident would be to give an utterly strange meaning outside the purpose of the statute. Axon and Warboys was the well-known date rape case. Mr. Warboys was a taxi driver, and he used to give alcoholic drinks laced with a sedative to young women in the taxi and committed sexual assaults on them while in the taxi. The judge held that the chain between the defendant's use of the taxi at the time of the instance and the claimant's injury was broken by the acts of poisoning and committing sexual assaults. The injuries arose not, contrasted Dunthorne, with any wish to continue the journey, but instead because the defendant wanted to poison the claimants to facilitate and implement his wish to sexually assault them. And that was a factor which is not connected with any use of the vehicle on the road. The case is instructive for three reasons. First of all, it shows that the facts relevant to the issues of use and arising out of may well overlap. Second, it recognises the use of a vehicle may change in the course of the journey. And third, as Mr. Justice Silver said, although a proximate cause is not needed, a relatively strong degree of causal connection is required. Wastell and Woodward was a case involving a burger van. The defendant had this van, which was parked in a lay-by on a main road. He placed a sign advertising his wares on the other side of the road. Having done so, he stepped back into the road without looking and into the path of a motorcyclist who crashed and was killed. Master Davidson, citing Vanook, held that the accident arose out of the use of the burger van, even though it was not being used as a motor vehicle at the time. He referred to the fact that in that case, and I quote, temporally, geographically, and qualitatively, the accident was closely linked to the use of the van on the road as a hamburger van. But the two first criteria, temporally and geographically, are at most necessary rather than sufficient conditions for the requisite causal nexus. And qualitatively really just begs the question, in effect, by substituting another word of indeterminate meaning for the phrase arriving out of. The decision was appealed but compromised before it was heard. I've always thought it was one that was wrongly decided, and the 2022 Motor Vehicles Act would probably result in a different outcome in the future. I dealt with pilling already. Dunthorne was most recently considered by the High Court in Carroll and Taylor. This was a bit of a long shot, it has to be said. The claimant had been a passenger in a taxi driven by the defendant. The claimant was drunk, and the driver took the opportunity of defrauding him and drove off, leaving him 3 miles short of his destination. Having walked for over 40 minutes, the claimant accidentally fell over off a flyover and was seriously injured. And it was held that the injuries did not arise out of the use of the taxi. The judge commented that while pilling, it was held in pilling that Dunthorne was a borderline case, and Mr. Dunthorne's case was close to the line. He said what she said was, while this case, her own case of Carroll and Taylor, was clearly on the wrong side of the line, the facts of Dunthorne and Bentley are likely to be instructive as to which side of the line other cases, including this one, fall. Permission to appeal was sought. Lord Justice Stuart Smith, in refusing permission, said there must be a reasonable limit to the length of the relevant causal chain, quoting, I think, what Lord Hodge had said in Pilling, where he quoted an earlier Scottish case, saying, "It is of course logically possible, as every schoolboy knows, to trace the lot of a battle or even of a kingdom to the absence of a nail in a horse's hoof. But strict logic does not appear to me to be a safe guide to the decision of questions such as this." Do we get any help from Commonwealth cases? Well, the English courts have always been rather ambiguous about the use of Commonwealth cases as an aid to the interpretation of this provision. In Pilling, for example, Lord Hodge said that he had not overlooked the Commonwealth cases, but then went on to say that he didn't find them helpful. In fact, cases both before and after Dunthorne and Pilling have considered them. Carroll and Taylor most recently made extensive use of the Canadian cases. The reason is that Canadian motor policies have, or at least had to cover, claims arising out of the ownership, use, or operation of motor vehicles, which is similar or broader than Section 143 of the RTA. So it may perhaps be argued that if the Canadian courts have rejected a claim being too remote, it should also be rejected in England, although perhaps not the other way around. Moore's taxi is the best known of the Canadian cases. It's referred to in several of the English cases. What happened there was a taxi driver let a child out of a taxi opposite its home to cross the street alone. The child was and seriously injured. The court was concerned with the construction of a clause in the defendant's insurance policy which excluded claims arising out of the ownership, maintenance, use or operation of any motor vehicle. It was held that because the vehicle was stationary and the chain of causation originating with its use was severed by the intervening use of the taxi driver in failing to escort the child, the exclusion clause did not apply, so that the insurer had to meet the claim. In fact, there are another half dozen or so Canadian cases involving pedestrians, usually children, some going one way, some going the other way after they've left cars. No consistent picture appears. More recently, the Supreme Court of Canada has laid down, in the case of Amos, two principles which have to be applied. First of all, did the accident result from the ordinary and well-known activities to which automobiles are put? That's roughly equivalent to the use provision. Second, is there some nexus or causal relationship, not necessarily direct or proximate, between the ownership, use or operation of the vehicle, or is the connection merely incidental or fortuitous? As luck would have it, you don't get much help from the other Commonwealth jurisdictions. First of all, New Zealand, because it's got a notable compensation scheme. And secondly, Australia, because it uses different words in its legislation, resulting from, as I think one used in many states. Dickinson was a case, an Australian case referred to in Dunthorne and some of the other English cases. In that case, the claimant was a 2-year-old girl who'd been left in the car with her brother, who was 4 years old. The father had parked the car temporarily to go to a nearby shop. The claimant's brother was playing with some matches in the car and set fire to the car, thereby injuring the claimant. The claim succeeded against the driver and his motor insurers. It was held that the test posited by the words arising out of is wider than that posited by the words caused by. And the former, even though it involves some causal or consequential relationship between the use of the vehicles and the injuries, does not require the direct or proximate relationship which would be necessary to conclude that the injuries were caused by the use of the vehicle. So what about road rage in English law? I was involved in a case earlier this year, which was in fact compromised before trial. The facts were these. A motorist in South Wales was more than a little irritated by having to follow a cyclist at a slow speed for over a mile on a narrow road. When he eventually overtook him, words were exchanged, to put it mildly, between through the car window. The motorist pulled into a pub car park on his near side, half a mile down the road, got out of the car and waited for the cyclist to come past. As the cyclist did so, the motorist punched him off the bike so that he fell into the path of an oncoming van, driven non-negligently, and was seriously injured. Was the motorist using his car in any material time? And if so, did the injury to the cyclist arise out of that use? As for use, if Lord Hodge's quotation, which I gave you above, has been strictly applied, it might be said it was in use at the time. If so, did the injury arise out of that use? There must be a reasonable limit to the length of the relevant causal chain. The reason why the motorist punched the cyclist was in no way in furtherance of his journey, as was the case in Dunthorne. And it could legitimately be said, as the judge had said at the criminal sentencing hearing in relation to the motorist, that the injury arose out of his inability to control his temper rather than anything else. The case, as I say, before trial, so there was no decision on the matter. You do get some interesting cases from Canada, however, on road rage. In view of the time available, I'll just mention two of them. First of all, Duval and Alberta Motor Association. This was a first instance decision from Alberta. The insured was driving his pickup truck on a street in Alberta. He was passed and nearly boxed in by the action of the victim, who was driving another vehicle in the same direction. He followed the victim to the next set of traffic lights, where the victim's vehicle was stopped immediately ahead of him. He exited his vehicle and assaulted the victim in the victim's vehicle. Justice Marshall rejected the claim, holding that, and I quote, the connection between the assault and the use or operation of his, that's the insured's automobile, appears to be, quote, merely incidental. There must be some nexus between the assault and use or operation of his vehicle. By contrast, look at ICBC and Garnier, another recent case, this one from British Columbia, a different conclusion was reached. There was what was described, first of all, as a contested traffic maneuver, and following that, the claimant was assaulted at traffic lights by the other motorist using a baseball bat. It was held that did arise out of the use of the other or operation of the other motorist's vehicle. In doing so, it distinguished a considerable number of earlier Canadian decisions where a contrary decision had been reached. But it must be remembered that these and many of the other Canadian cases, the test has been applied as the two-part test in Amos, which, as I said above, may or may not be coincident with that to be applied in England. Just in the time available, let's have a look at some other incidents involving motor vehicles. First of all, pedestrians. Well, the case of Slater and Buckinghamshire would suggest that an accident to a pedestrian before he reached the vehicle is unlikely to be held to arise out of its use, although this may, of course, depend on where it's parked. An accident to a pedestrian leaving the vehicle may arise out of its use. For example, if the vehicle is dangerously parked, or if the pedestrian had to leave the vehicle by a street side rather than the pavement side. Passengers, well, it's an interesting one. There's another of the Canadian cases, Tench and Erskine, where the person who assaulted the other driver was the passenger. It was held it didn't arise out of the use of the vehicle in any event. So the question of whether the passenger could be a user didn't arise. What about cases before or after a journey? As far as after is concerned, you can get some guidance from Carroll and Taylor, and there's another Canadian case called Fraser on remarkably similar facts, and I think it's unlikely to be held there unless there are unusual circumstances that arose out of the use of the vehicle. But what about before a journey? Supposing someone's about to get into his car with his young child, he's holding the child's hand, he fumbles in his pocket for the keys, and in order to do so, lets go of her hand. She runs into the road and is injured. Does that injury arise out of the use of the car? What then about cases where the use is purely incidental? Cases such as Axton and Warboys illustrate the point that if the motor vehicle was merely incidental, that was the Date case, or the Rehybnol case, merely incidental to the occurrence of damage, the courts will probably hold either that there was no relevant use of the vehicle, or the damage did not arise out of that use. Canadian law gives rise to all sorts of weird and wonderful cases. Citadel and Blightingham is one, where a motorist was injured by rocks dropped from a vehicle on a bridge above. It was held that the injury did not arise out of the use of the vehicle. But on going the other way, Boyle and Schinkel, in that case, a dog jumped out of an open car window and collided with and injured a passing motorcyclist. It was held that the injury did arise out of the use of the vehicle. So that there are many cases going each way. As I say, you may well get some assistance from Canada or indeed elsewhere in the Commonwealth. All that can be categorically stated is that we know there is a line between cases that fall within Section 145 and those that don't. We can, as it were, colour in by reference to decided cases which have fallen in on one side of the line or the other. Just where that line is to be drawn is what Donald Rumsfeld might call a known unknown. Thank you very much for listening. And if Howard or I can assist in any way with questions by email or otherwise afterwards, we'd be very happy to assist. Thank you very much.